So yes, in the last class, I think we discussed about Austin's justification for uh, positive law, and then his views on um, common law, okay, judge-made laws, which is quite different from another fact positivist, that is Bentham, okay. Whereas Bentham does not think common law is worthy of being called law. For Austin, it is one of the most important developments, in law. Okay, so it is very much part of what he calls as positive law, and it is probably, according to him, better than even the legislated laws. So that's because he thinks that judges have been delegated the power to make laws by the sovereign. Okay. Now, yeah, that's what we had done. Okay. Now let's proceed to Austin's categorization of what he calls as different kinds of laws. Okay. So yes, he essentially says that there are those laws that can be called as laws properly so called. Okay. And then there are those laws which are not laws properly so called. Okay. And they are, you may call them as laws, okay, but they are not laws properly so called. They are laws by analogy, as he says. Okay. Now, as you know, you hear about many different kinds of laws. So, for example, you hear about divine law. Okay, you hear about constitutional law. You hear about customary law. You hear about international law, moral laws, etc., etc. Okay, as you know, just like most other positivists, his view is more or less the same. That what is the concern of a jurisprudent? Okay, what is the concern of a jurisprudent? He says that the concern of the jurisprudent is essentially positive law. Okay, now positive law for him definitely is laws properly so called. Okay. However, there is one more law that is known as laws properly so called. Okay, so that's essentially the divine law. Okay, lex divina. But not all aspects of divine law will be considered as laws properly so called. Okay, only the scriptures. Okay, this more specifically because he was a Christian. Okay, so only the authority of Christian scriptures, um, is taken seriously by him. Okay. So that's okay. So Christians, so what is revealed by the God, okay, through the scriptures will be considered as laws properly so called. Now, how does he differentiate between laws properly so called and laws, which are not properly so called, okay, or improperly so called, or laws by analogy, okay? So the essential difference is that of authority. Okay. So in case of laws properly so called, okay, those laws are derived from some authority. So when he says authority, what does he essentially mean? Okay. So whatever has some kind of power of imposing it on you, essentially, that's what you need to understand it as. Okay. So what is that? So, for example, God is omnipotent, omniscient, whatever. Okay, God clearly has power over you. So, because God is capable of imposing His dictates on you, so you can say that God is clearly a case of authority. In a similar way, there could also be human superiors. Okay, who has okay, certain control over you, okay, certain power over you. In such case, that determinate human superior is able to impose his will upon you. So in such case, that human will be okay, authority here. Okay, so the laws that emanate from those authorities are essentially what he calls as laws properly so called. Okay, so there are two different kinds of laws properly so called. One is the lex divina, and the other one is the legislated laws. Okay, legislated by who? So sovereign in a particular political community. Okay, so that's essentially the idea. Okay, so yes, now out of these two different kinds of laws properly so called, okay, one is the concern of the jurisprudent. Okay, it is the second one, not the laws emanating from scripts, okay, as willed by God, okay. That's the separate inquiry, okay. So the concern of jurisprudence is the laws which are posited by some human superior, okay, the political superior, okay, who's a human, okay. Laws emanating from that will be is considered as positive law, okay. And positive law is the exclusive concern of jurisprudence, okay. And who deals with the laws of God then? So that's a separate, branch of study, okay. That's the subject of theology. But the question still remains, can't a jurisprudence deal with them? Well, for him, he does not give you any reason enough, to say that why, all those other laws should not be concerned of a jurisprudence, okay. He merely says that, I think, as you know, we started with his justification at the end of the day for this would be his utilitarian philosophy. That it is better that we stay clear about what is law, okay, what is law, what is the law, rather than going into its moral merits, okay. So for that reason, he says that yes, positive law should be exclusive concern of jurisprudence. But then laws of God are also clear, then why should that not matter? He does not give us any more reason than this, okay. So kind of arbitrarily he says that we should concern ourselves only with the laws posited by humans, okay. And then he draws a distinction between law and morality, which we all know. So as you already know, further, when he talks about positive law, okay, what is the position of common law and customary law, okay, within that, okay. So as you know, common law is very much part of that positive law, okay. Now what is the reason? It is because those judges who adjudicate, okay, they have been delegated the duty of, applying the law in specific cases, okay. So, it is not possible, as you know, as he admits, okay, for the sovereign to foresee every single specific cases that emerge in the future. So in such case, those gaps in the law are ultimately filled by the judges, okay. So where does the judge derive that authority from? According to Austin, that authority comes ultimately from the sovereign itself, okay. So yes, that is essentially the idea. Now, then one question that you might raise that, okay, so for example, today a particular law, a ratio in a case has been decided which becomes a law. Okay, we are to assume that that is the will of the sovereign, okay. But what if tomorrow a law is enacted by the sovereign, a law is posited by the sovereign, okay, which goes against the judgment laws, okay. In such case, it is quite clear that, the subsequently enacted legislated law will supersede the laws made by the judges. So it's very simple in his philosophy, okay, what happens, okay. It's not merely by the principle of lex posteriori, no, not that. It is simply by virtue of the fact that the judges have legislators have enacted the law which will be ultimately considered as superior to the laws which we presume to have been made with the authorization given by the sovereigns, by the judges, okay, to the judges. So yes, that's the position of common law. Then what is the position of customary laws, okay? So for our philosopher here, for Austin, okay, custom in itself will not be a law, okay, will not be a law. What is the reason? If you apply the reasoning that we had applied earlier, okay, he says that the laws have to, emerge from authority, okay. In case of positive enacted law, we know where it comes from, but when it comes to customs, so for example, there are 10 people and there is a customary practice, applicable to them. Who has created the custom? You will not be able to pinpoint it, okay. So that means we cannot, point to the exact authority there. And because it does not emerge from some authority, so we cannot, custom in itself will not be considered as laws, okay, laws properly so called, okay. But then, quite often judges adjudicate matter in the light of customary practices that exist in a certain place, okay. In such case, when through their judgments some recognition is given to certain customary practices, then what happens? So in such case, once the recognition has been given by the court to those customary practices, then you can assume that, okay, now it is law properly so called, not because it is a particular custom, but because it has been recognized as the law by the judges interpreting the said custom in a particular case. Okay, so he wrote that now when customs are turned into legal rules by decisions of subject judges, okay, the legal rules which emerge from the custom are tacit commands of the sovereign legislature. So that's what essentially happens. Once the judges have adjudicated a particular matter based on any customary practice, then you can say that, you can assume that yes, through the judges, the sovereigns have basically issued such command. Okay. So yes, that's essentially what the position of command customary law is. So is it clear? Is it clear to you guys so far?
Yes, sir.
Okay. So apart from that, okay, what about so for example, until you are measured, there are certain things, okay, there are certain decisions that can be made by your parents, your guardian with regard to you. Okay. You know that certain companies can make rules, regulations, which are binding upon its employees. Okay, so what about all those cases? Okay, what kind of laws are they? Okay, because they do not emanate from the political determinate, political superior here. Okay, what about those? Okay, so for him, even in those cases, you will ultimately say that it emanates, okay, it emerges from the sovereign. What is the reason for that? Okay, so that authorization, for the parent, for the guardian, or for that matter, the corporation, company, okay, would ultimately emerge from from the sovereign. Okay, that sovereign authorizes you to make the laws. Without the authorization from the sovereign, you will not be able to make those laws. Okay, so that's essentially his justification. So even in these cases, ultimately it is a case of tracing the will of the sovereign. Okay, and there could be only one sovereign. Okay, that we will discuss. Okay, so this is what he says about laws properly so called. So there are two different kinds of laws properly so called. One is the lex divina, or what you get from the scriptures, not the unrevealed part, because with regard to unrevealed part, there is disagreement, okay, among people. So we do not want to revert back to not having clarity. So that's not considered as laws properly so called. Only the revealed part is considered as laws properly so called. But one thing that he does not address is that even when it comes to revealed scriptures, there are lots of disagreements about what they convey, what they mean. In fact, there are so many Christian, denominations, essentially because of their different understanding of what scriptures say. So he does not address that. Okay, he just simply says that lex divina is law properly so called. On the other hand, the other aspect of the other laws properly so called would be that which is posited by the sovereign. Okay, that also includes common law. And this positive law is the sole concern of a jurisprudent. Okay. Then the other kind of laws, okay, that he identifies, he calls them, okay, laws improperly so called. Okay, and why are they called laws? Why are they called as laws improperly so called? It's simply because, as you know, the definition of laws properly so called is that they emanate from from authority. Okay. Because it emanates from authority, there is clarity about what it is, okay? Whereas all other, laws that we, by analogy call as law, okay, that we usually by practice, by habit maybe call laws, okay, they do not emanate from authority, okay? They are essentially based on differing, opinions, okay? So because, these so-called laws, improperly so-called, okay, because they emerge from opinion rather than authority, they are not the concern of jurisprudence, okay? Because there will always be disagreements about them, okay? So sometimes they resemble, the features possessed by laws properly so called, but they are not laws properly so called. Okay, they are known as laws by analogy. Okay, or laws by caprice, or caprice of the fancy. Okay, so and among within these laws, improperly so called, there are two different kinds of laws. Okay, that he identifies. The first one is more specifically laws by analogy, and the other kind is essentially laws by metaphor. Okay, now laws by analogy resemble to a great extent what we understand as laws properly so called, but laws by metaphor are the farthest from what we essentially understand as law. Okay, so what are laws by metaphor for him? Okay, so those are essentially scientific laws. Okay, laws of science. Okay, they merely describe physical phenomenon. Okay, the things that happen in the physical world. Okay, and if you know them, you will be able to predict future happenings. Okay, so it's essentially about cause and effect. Okay, and the laws that help you in predicting what will be the effect. Okay, so the laws of science or scientific laws, okay, are what he calls as laws by metaphor. Okay, so they are the farthest from what he understands as laws. Okay, but then there is another laws improperly so called, known as laws by analogy. Okay, so why does he say they are laws by analogy? It's simply because they seem to be like the law, positive laws. Okay, but the problem with them is that ultimately they depend on opinion. Okay, so what could all those be? Okay, so those could be your customary laws. Okay, those could be the rules that you might have within your household. Okay, different moral laws. Okay, moral precepts. Okay, it could also include your customary laws. Okay, international law and constitutional law. Now, why does he say so? Okay, why? Okay, we can probably understand that maybe certain moral rules, okay, household rules, other etiquettes, okay, social practices, are considered as laws by analogy. Okay, but why are customary laws, international laws, constitutional law not part of this laws properly so called? Okay, it's simply this, that all these three different kinds of laws that I have just mentioned, they ultimately do not emerge from authority. So I explained the problem with customary laws already. Okay, you cannot trace the person or group of persons from whom this customary law emerged. Okay, so because of that, it is not laws properly so called. But it becomes laws properly so called once it has been judicially recognized. Okay, by that we also assume that the sovereign has also recognized customary practice. But when it has been recognized, it is law properly so called, not because it is a customary practice, but because it has been recognized. Okay, as simple as that. Now, what about international law? Okay, now with international law, the problem is that he says that it is nothing but positive morality. Okay, it is merely a case of positive morality. Now, why does he say so? The reason is simple: it does not come from a sovereign, or it does not come from one authority. Okay, so international law for him consists of differing opinions and sentiments which are basically in practice prevalent among nations. Okay, because it is a matter of opinion, because it does not emerge from authority, he does not consider as laws properly so called. Okay, so that's why he criticizes many other philosophers who considered international law as laws properly so called. Okay, as you know, we have studied Hugo Grotius, who said international law is a law, and his justification is because it's some you derive it from some higher law, isn't it? We had already discussed, okay, about the first principles that he talked about. But Austin does not believe in all this nonsense. Okay, so he says that there is still possibility of people disagreeing about what international law is, which is in fact the case, as you know. Okay, see, when Universal Declaration of Human Rights was adopted in 1948, the two blocks, okay, disagree, okay. Some said that, okay, only civil political rights are considered as human rights, whereas the Soviet bloc said that, well, only socioeconomic rights are considered as human rights. So you then needed to separate, covenants, okay, ISSCR and ICCPR. Even then, some countries adopted one, others adopted the other, and then when it comes to domestic implementation, then far more complexities arise that we will deal with. So you have this monism and dualism that we will have to deal with later on. So why am I telling you guys about all this? It's essentially to point you to this, that when it comes to international law, there is huge disagreement among sovereign nations, okay? So ultimately, what it means and what is the substance of international law essentially depends on how it is understood. So it is by different sovereign nations. So it ultimately boils down to differing opinions and sentiments, as he says, are prevalent among nations. So because it does not emerge from authority, okay, it is not a law properly so called, but he considers it as positive morality. So Holland, another jurist, okay, Holland had said that international law is essentially vanishing point of jurisprudence. So for this reason, essentially, but many would disagree. You might be asked in international law class later on why Holland said that international law is vanishing point of jurisprudence. This is the reason that there is no higher authority. So if in distant future you have a world government, okay, and that government has power over everyone, then in such situations, that sovereign that exists at that level, okay, the laws emanating from that might be considered, even though it's of international in nature, you might consider it, you will then consider it as a law properly so called. But until then, it's for Austin merely a case of positive morality. But then, okay, what about treaty agreements between different nations? Okay, so one country enters into a treaty with, treaty agreement with another country. Okay, so it's of the nature of contract then, isn't it? That two countries make promises and then promises ought to be kept. Okay, so it is essentially based on this principle known as pacta sunt servanda. Okay, so promises ought to be kept. Okay, good faith. Okay, what about that? Okay, what about obligations arising out of such mutual pacts? Okay, mutual promises that nations make towards one another. Even in such cases, okay, what keeps the sovereign from going back on the promises that it makes? Okay, if it is not capable of doing so, then it is not a sovereign. So even in such situation, okay, for him, it is nothing more than a case of certain principles, okay, certain moral principles. So even in those cases, okay, international law is nonetheless a case of morality. So yes, you cannot be certain that what has been promised would in fact be respected, would in fact be honored. Okay, so that's essentially his idea of his view on international law. And then so we have one more law, that is constitutional law. What is the case of constitutional law? Okay, we understand constitutional document as some kind of higher law than any other ordinary enactments. And in most of the legal system, amendment of the constitution is made difficult, okay, much more difficult than enacting an ordinary piece of legislation. Okay, so what about that? Well, in Austin's philosophy, even constitution, okay, will not be able to, or he said should not, should I say should, because that connotes something of moral nature. He says that is again a case of morality. Okay, you may talk about constitution, but at the end of the day, it will depend on whether the sovereign is willing to respect it. Okay, is willing to respect it. So it at the end of the day depends on the goodwill, on the on how sovereign treats the constitution. Okay, this is something that you will probably see in the case of that habeas corpus case. Idiom, I think, what was it? Idiom Jabalpur Shivkan Shukla. Okay, in that case, you will see, except for Justice H.R. Khanna, all other judges took this Austinian position. Okay, that even those rights guaranteed to you, your right to life, could be denied if an emergency has been imposed. Okay, and those rights have been taken away or suspended. Okay, who imposes the emergency? Let's assume that it is the sovereign, whosoever is in political power. So if that has happened, then no matter how entrenched your right to life or liberty is in the Constitution, it does not matter, okay? Because ultimately it's the sovereign who prevails, okay? But then, Justice H.R. Khanna disagreed, okay? He had a different, view on this whole thing. So anyway, we will discuss about this later, but this is for now just introductory. So yeah, that's his position even about constitutional law. Ultimately, it's the case of goodwill of the sovereign, whether he or he is willing to accept it as a constraint on him. So that's essentially different kinds of laws. So laws properly so called, then laws improperly so called. Laws properly so called emanate from authority. Laws improperly so called do not emanate from authority, but they're based on opinion. So that's essentially the how we distinguish between these two different kinds of laws. And within the laws properly so called, it's only the laws properly so only the positive law is the concern of jurisprudence. Okay, so what is positive law then? How does Austin define positive law? Okay, so in the idea of positive law that he defines, there are three different elements that are required. Okay, so he says law is the command of sovereign. Okay, law is the command of sovereign. So what are the and if you do not observe the law, okay, the consequence will be in terms of sanction. Okay, so from this definition, there are three elements that we see. Okay, that you need a sovereign. Okay, you need a political sovereign. Okay, the political sovereign issues command. Okay, command essentially tells what you to do and what you are not to do. Okay, and if you do it or do not what you've been commanded or prohibited from doing, then there will be consequences in terms of sanction. So if these three different elements are there, we call it as positive law. Okay, so remember, even common law will come within this idea of positive law. Okay, so law is there only if there is sovereign. Okay, if there is no sovereign, there is no independent political society, and if there is no independent political society, there is no sovereign. So a kind of hubris, a kind of superiority you will see in the definition given by Austin. Okay, so his definition was reflective of the society that he was part of. Okay, so essentially, and when he was giving this definition, they had the crown in parliament, okay, as the sovereign, as you will see in his definition as given. Okay, so but there were many other places, okay, around the world where people did not have the same kind of sovereign as Austin is talking about. So does that mean they do not have any law? Well, according to Austin, they do not. Okay, and they are not politically independent society. So apparently that's the justification for colonialists to go there and give them law. Okay, they become the determinate human superior. They become the sovereign, who will rule over them, and thus they will give them their exalted laws. So that's essentially the problem with the definition of law that he gives. But you know what he's talking about. Okay, there has to be sovereign. Okay, if there is no sovereign, there is no law. And the presence of the sovereign means that the society is independent political society. Okay, if it is not independent political society, then there is no sovereign. Okay, so that's essentially what he's talking about. So once you have the sovereign and the sovereign issues command, then there is law, and it is law when it is followed by some kind of sanction. Okay, so all these three elements have to be there at the same time. Okay, so that's what he considers as law. Okay, now let's look at the first element of his definition. He talks about sovereign. So what is a sovereign? Okay, so the sovereign, okay, his definition is like this. Okay, the sovereign has to be a human, okay, because that can only be the authority, okay. It cannot be an animal. An animal will not be able to command anything to you. It is definitely not God, because that's a different law, as we have discussed. So it has to be human, and it cannot be all the population equal for him, because then it is not determinate enough, okay. So he says that his definition is like this, okay. Who is a sovereign? He says, if a determinate human superior, okay, so sovereign has to be a determinate human superior. It could be one person, or it could be a class of person, but it has to be determinate human superior. Then he says, not in a habit of paying obedience to a like superior, okay. It should not pay any obedience to a like superior. So superiority is very important here, okay. Receive habitual obedience from the bulk of a given society, okay. So if you are superior, you have to receive obedience from the bulk of the given society. It says habitual obedience. So that's usually the practice, in the political society that he's talking about, okay, from the bulk of a given society. That determinate superior is sovereign in that society, okay. So in that case, that determinate superior is the sovereign in that society, and the society, including the superior, is a society political and independent. So that's essentially the relation between sovereign and independent political society. So you have independent political society if there is a sovereign, or you have sovereign. If you have sovereign, then you have independent political society. So most of these stupid Eastern people, okay, they are essentially bound by customary laws. They do not have political determinate human superior, okay, as sovereign ruling over them. So they are not politically independent. So let's make them politically independent by giving them a sovereign, okay. So that's the kind of definition of law that you see here, okay. Now let's go into the details. I think the time does not permit. We will complete this discussion tomorrow. So if you guys have any confusion, then you can ask.